Thank you, Madam Speaker. I'm grateful for this opportunity to add to what I hope are meaningful words on today's bill. How we in this place can act to prevent intimate partner violence is an issue that has impacted my personal work here over these 8 years. I know it concerns all members in this place. Statistics Canada reports that in 2021, 537 women per 100,000 people were victims of domestic violence. Intimate partner violence accounts for almost 1/3 of the crimes committed in Canada and has increased 6% in the last year alone. Violent crime as a whole has increased 39%. Sexual assault has gone up 71%. This is part of a larger pattern of increased levels of crime after 8 years of this Prime Minister's catch and release bail policies. These statistics have an even greater impact when you consider that 80% of criminal activity involving intimate partners goes unreported. We must ask ourselves, why is this the case? Why is there such a lack of faith in our justice system? Why do victims feel that there's greater benefit in not initiating criminal proceedings? Why do they not feel protected throughout a traumatizing period in their lives? We can point to larger trends. Between 2004 and 2014, cases where failure to comply with a court order when they were among the charges grew by 25%, and the cases involving charges related to a breach of probation increased by 21%. When intimate partner violence is reported, insufficient steps are taken by the justice system to deter further violence, despite the fact that in 60% of homicides involving an intimate partner, there was a history of violence. Half of these homicides involve an offender who has already been convicted on similar offences. The senator sponsor of this bill referred to one particularly egregious case that I now put on the record in this House. In Quebec, an individual accused of a femicide had committed 50 criminal offences in his lifetime, including 3 sexual assaults and 11 instances of domestic violence. After violating his bail conditions a 3rd time, he was arrested but subsequently released. Just over 1 week later, he murdered his former partner. No wonder trust in our system has been shattered. For the sake of victims, we need to do a better job of listening to and acting on their concerns. S205 is about providing our justice system with every tool we can to empower victims of intimate partner violence to come forward when crimes do occur and ensure that their rights are placed above those of their offender from the start of the legal process. It would ensure that victims are consulted about their safety and security needs before conditions of release are imposed on an accused person. These conditions must take the victim's opinions into account. If the victim is an intimate partner of the accused, they have the right to be made aware of their bail conditions. A judge may choose to require the accused to wear an electronic bracelet upon their release, effectively creating a barrier between the victim and her attacker and ensuring that law enforcement is alerted if the safety perimeter is broken. The bill would also extend the length of peace bonds and increase penalties for violating them. Again, this proposed with the victim top of mind, allowing them a larger window of time after the attack takes place. Speaker, there is always more that can be done to bolster trust in criminal justice and to encourage victims to report their attackers without fear of retribution. But as it currently stands, an individual's condition of release is not subject to any monitoring mechanisms. This isn't fair to victims, the public at large, or our current understanding of intimate partner violence. What we know is not being reflected in the laws that we have. And that's why this bill is one of many initiatives that we should be adopting. I was pleased to speak in support of C-320, or the Truth in Sentencing Bill. It was just recently passed in this House with all-party support. The bill is another common-sense tool that ensured that we are prioritizing victims' rights over those of the offender. At the core of C-320 was transparency, ensuring that the victims are informed of why specific decisions are being made on an inmate's parole date, temporary absence, or work release. Those victims should know all of those circumstances in advance of them happening and have opportunity to contribute. I'm also proud of the work that I did earlier this year on protecting pregnant women from violent men through Bill C-311. We know that when women are pregnant, they are more susceptible to violence. And we know that this is something that takes place in our country more often than we expect it should well, we don't expect it should happen at all, but more than we realize often when these situations are not top of mind and they aren't handled within our court system in ways that draw more attention to the fact that these things are taking place. It was affirming to me to know that the majority of Canadians who read the bill for what it was, in other words, understood exactly what the purpose was, the intent was, very straightforward, knew full well that it would have provided judges with new aggravating factors that are not consistently enforced at this time. In other words, a judge can choose to consider that fact that the woman was pregnant and that the child was injured, but they are not required to. And this is just another scenario where, like this bill, we need to do everything that we can to protect women in situations of intimate partner violence. You know, there's a common theme amongst all of these bills. Victims believe that the justice system is not there for them when they choose to report their abuser. It's very clear with the number of catch and release bail circumstances we find taking place in this country where violent crimes are continuing to take place through that individual. And we need more deterrence, more reasons for them to reconsider or not commit the crime in the first place, but also to ensure that they are not carrying on with crimes when they're released prior to facing their court cases or when they are released on bail. Believe that, individuals who are victims of violence believe that the subsequent steps that are being taken by courts after they have come forward and taken the risk of presenting their case of being attacked or abused, that they are being left at risk. And this bill, S-205, would make a significant difference to that situation. It takes a proactive approach. In other words, we're not waiting for another horrific situation to take place. We are curtailing them. And that is just common sense. This is a common sense bill. It's about putting the victim at the center of the judicial process and give them more power to participate in the process right from the start, so that when that individual is facing charges and is being released, even in that circumstance, the preference is being given to protecting that victim in those circumstances. So I believe that we need to do everything we can in this House to pass any bill that protects women from violence. And that is certainly the case with S-205, and I encourage this House to move quickly on it, efficiently on it, and make sure that it enables us to reflect even more on the opportunities that we have in this place that sometimes we don't take for political reasons, which just, believe me, for those who face violent crime, cannot understand why we do not take every opportunity we have to do more to protect victims and to ensure that victims are cared for. Thank you so much, Madam Speaker.